Welcome to Rebel Chaser. My name is Gail, and I've got a video for you from Judge Lee in Kansas. I'll let you guys watch.
Good afternoon. I'd like to have a brief meeting with council before we get started, if I can. Can we do a break out there?
Yes, sir. Would Your Honor like us to have our clients wait in the hall?
Attorneys, just the attorneys right now. All right. Now we got that taken care of. This is in the matter of the marriage of Benjamin Beller versus Kristen Beller, case number 25 DM14. If counsel would announce their appearances, please.
Joshua Andrews on behalf of the petitioner, who is also present in my conference room.
Your Honor, Lucy Hess on behalf of Kristen Beller. She's present with me in conference room.
All right. And as indicated, we'll have a pretrial or case management meeting on January 26th at 2 p.m. That'll be a Zoom hearing slated for 1 hour. Today we're here on request for modification of temporary orders. And in our conference, there were certain things I think that the defense was not, or Mr. Andrews' client was not opposing. Excuse me. So let's get, if we can get that on the record first, and then we'll concentrate on the issues that are still in dispute. Mr. Andrews, could you go through that again, please?
Yes, Your Honor. My client has no objection to the requested order set forth in paragraph 26, subsection B of the motion to modify temporary orders, which
26B.
26B, as in boy, that grants temporary possession of the marital residence to petitioner, and that respondent be given 72 hours to vacate the residence. Mr. Bellar has no objection to the requested orders in 26C, as in Charlie, which is a list of personal properties that respondent would be granted temporary possession of. Mr. Bellar has no objection to the request in paragraph E, 26E, that he be responsible for the taxes, insurance, tags, and maintenance on the 2006 Dodge Grand Caravan, the cell phone expense. Sorry, let me. The joint Capital One credit card and the farm credit loan. He does object to the request that he be responsible for the respondent's uncovered health and dental expenses. And I apologize, I missed that one earlier when we were discussing this off the record. And he also objects to the request that he be responsible for the Capital One credit card in respondent's sole name. He does not object to the requested order in 26F that he pay all financial obligations in his name alone and in the name of the business that he or the parties have a direct interest in. He does not object to the order in paragraph 26G that enjoins the parties from drawing against any business accounts other than for the express purposes of operating the business in the usual and ordinary manner. And he does not object to the request in paragraph I that child support be established pursuant to the guidelines However, he does object to the proposed child support amount contained in respondent's child support worksheet.
Well, before I hear arguments on that, in regards to the health and dental expenses not covered by insurance, is there something outstanding that needs to be dealt with before our next hearing?
I did not believe that there were any outstanding medical and dental expenses. The way I understood that request was to be responsible for future medical and dental expenses that may be incurred.
Ms. Hess?
That's how it was written, Judge, just as a temporary matter.
Okay. And okay, there's two Capital One credit cards, one that's in the respondent's name and one that is in both parties' names. The one that's contested is the one in respondent's name. Different couples have different way of managing their money. So what's the circumstance with that, and what sort of that's on that card?
I don't believe my client has any real knowledge as to what the individual card was used for, Your Honor.
That's the last amounts left for coming out of my bank.
It looks like the amount that has been paid out of the joint account has been different monthly. So I'm not sure if that is an indicator that the balance has been paid in full each month, but it looks like on October 14th, $865.28 was paid towards that credit card. So again, it being a credit card that's only in Ms. Bellar's name, I don't know if there was an outstanding balance left after that payment, and whether new charges have been incurred on that card.
Ms. Hess, you want to address that?
Your Honor, Ms. Bellar informs the court that that the amount on this card that's incurred monthly or just for monthly household expenses that are outlined on the domestic relations affidavit. She pays this off in full every month. So.
All right, so that may be more addressed in the request for support and maintenance, correct?
That's correct.
Okay. Any other agreements, Mr. Andrews?
No, Your Honor. Other than we would, I guess, and I apologize for not mentioning this earlier either, but because I just keep thinking about it. But we would also be in agreement to an order. This was not a requested order, but we would be in agreement to an order mandating that neither party transport the minor child unless all legally required child safety restraints are being utilized. I know that was a concern that was addressed in the motion.
Okay. Very well, thank you. Ms. Hess, I'll hear you now on your motion.
Yes, Your Honor. Good afternoon. If it may please the court, Kristen Beller respectfully urges this court to grant our orders and our proposed orders in its entirety. At this juncture, the temporary orders that are currently in place are not sufficient to permit the parties to begin the process of separation. Our motion requests modification of the temporary parenting plan, order pursuant to guidelines, award of spousal maintenance, award of personal property, and a request for debts to be temporarily allocated. As have already been put on the record, many of those have already been agreed to by Mr. Andrews' client, Mr. Bellar. But we will address the remaining issue of the additional account as when we come to the request for spousal maintenance. As you're aware, the big remaining issue is the adoption of the temporary parenting plan. Our motion included a proposed parenting plan pursuant to KSA 2707D. And it is at Exhibit H. And this parenting plan is in the child's best interest. This parenting plan awards Kristen Bellar primary residential custody of the minor child, Adeline, who is age 2, and gives reasonable parenting time to Mr. Bellar. Your Honor, the first reason why you should grant this motion is that respondent is the primary caregiver. She's a stay-at-home mom, and she's been stay-at-home mom since Adeline has been born. She's unable to work due to her disability. Benjamin, as you can see by his domestic relations affidavit, as well as by the tax returns that we filed as exhibits in this case, has a number of businesses that he works for. First, he works as a farmhand for his parents' farm. He runs a trucking business, and he has a share in another business, Bellar Brothers. Functionally, he works farmer's hours. He's up early, goes to work early in the morning, is often not home till late at night. During harvest, he works longer hours. His requested parenting plan is not functional because it requests shared custody of the minor child, essentially a week on, week off. To accommodate this, he would need to find some daycare during the days that he has this child, which doesn't functionally make sense because Ms. Bellar is ready, willing, and able, and has been the primary residential caregiver for Adeline up to and throughout the course of this divorce. If you compare the parenting plans, it doesn't make sense to switch a 2-year-old child to a week on, week off schedule. She's been accustomed to living at home with both parents, and our parenting plan allows her to see reasonable parenting time with Mr. Bellar at least once a week on Wednesday evenings and every other weekend. This is a consistent parenting plan that allows Mr. Bellar to see his daughter on a reasonable schedule and allows Adeline's needs to be met. Second, she's alleged and verified under oath some serious concerns about respondent's ability to effectively parent a 2-year-old, and he's created some situations where she's physically been endangered. This includes multiple instances where when the child's been residing at home with both parents, he's failed to supervise the child. This includes instances on September 16th of 2025 and September 29th of 2025. Multiple instances where he's failed to transport the minor child in the car seat, and instances where in the past he has basically shrugged this off. So, Judge, while they say today that they're willing to agree to an order saying she needs to be transported in a car seat, if he's providing the bulk of the transportation for a week, and isn't essential, and my client doesn't have eyes on the child, how do we know that she's actually being transported? Here, Ms. Bellar would be doing the bulk of the transportation for the minor child. She would be, the child would be transported in a car seat. She would be safe. We've also outlined in our verified motion, instances where he's engaged in, physical discipline that we believe are inappropriate for a 2-year-old, as well as aggression towards the minor child. There are other factors that should be considered, Your Honor, such as emotional abuse of Kristen, which are outlined in the Kansas statute annotated 3203. Your Honor, when reviewing this motion, you need to take into consideration all of the statutory custody factors that are outlined in this case. And frankly, because of Adeline's young age, her dependence largely on her mother, her bond primarily with her mother, and situations where Mr. Bellar has not exhibited the best judgment when it comes to parenting, temporarily you should be awarding him parenting time and not primary residential custody. As such, we are respectfully requesting that you adopt our proposed parenting plan that we've included as Exhibit H to our case. The other issue, Judge, that remains outstanding in this case is adopting the child support worksheet that we filed contemporaneously with this motion. This worksheet appropriately sets Mr. Bellar's income at $104,195 a month. We believe this to be the appropriate income for the following reasons. First, he filed a DRA on August 7th of 2025, alleging that he had $9,343.42 in income. If a person is self-employed on the DRA, you need to include reasonable business expenses on an attached itemized exhibit. If you take a look at the file, Judge, there was never a reasonable business expenses itemized list attached. What you do have, Judge, is a tax return that is included at KB 15, under which you can assess some of the expenses that were incurred by the business, and you can determine whether or not those were reasonable. Under Kansas law, courts have consistently emphasized that not all business expenses are able to be withdrawn for the purposes of calculating child support, and specifically depreciation should not be categorically deducted or excluded as a business expense. Instead, the court must assess whether or not the depreciation contained therein is essential for income production. In failure to add that back and failure to demonstrate that, I'm sorry, Your Honor, ultimately the burden of proof lies with Mr. Bellar in this case, to show that the amount that he's claiming as reasonable business expenses in his DRA are appropriate. He hasn't demonstrated any appropriate issues. If you take a look at the Schedule C, that is contained in the tax return, you can't automatically treat the car and truck expenses or the depreciation associated therewith, other interest, office expense, or repairs and maintenance if they're associated with the marital vehicle, which was listed as part of the vehicles in this case. You shouldn't depreciate travel, meals and entertainment or other, which are undefined at this point for the purposes of calculating his income. Your Honor, what we propose to do in this case, one other thing to include is that he's in the past received in-kind payment as working for his parents' farm and does not presently pay rent on the marital residence. As it's provided through his employment on Bellar Farms. You see that by taking a look at his domestic relations affidavit where he doesn't list rent, and parties typically have not paid rent as part of their marital expenses. Your Honor, my recommendation for the purposes of today's hearing is that you treat 1/3 of his gross across all businesses that he's claimed, Beller Trucking, Beller Brothers, and any in-kind receipts from his parents' farm as income for child support purposes. And we calculated that as 100,000 for 195. Your Honor, we also are requesting adoption of temporary spousal maintenance in this case.
So before we get on to that, what's the bottom line that you're, for temporary orders that your client's requesting be paid for child support?
For child support, that number is $921 per month. And that is included as part of our exhibits. It is Exhibit F to our, that was included in our exhibit notebook. Starts at KD 73 and goes to KD 74.
Okay, now I'll hear you on the issue of maintenance.
Judge, in regard to maintenance, you have to do the two-step analysis. First is need and ability to pay. Certainly Ms. Beller has need. She is not presently able to work. She is a stay-at-home mother. She's done the lion's share of the child rearing in this case. And she does have a disability. If she is leaving the residence and essentially splitting off from Mr. Beller, she has to be able to pay her bills in some manner or form. Mr. Beller does have an ability to pay. If you take a look at his domestic relations affidavit, he has stated that he does have significant income. If you take a look at his proposed child support worksheet, he's even said that he has roughly $7,000 a month in income. So when you take into account the $2,050.33 per month that he requires as part of his regular bills, he is more than capable of tending to his needs. In order to essentially equalize and make sure that Ms. Beller is taken care of temporarily in this matter, we believe that an appropriate amount in order for her to clear her monthly bills would be $1,480 per month, which is simply a third of the difference in their incomes calculated out on a monthly basis, calculated by Johnson County benchmark guidelines. And that monthly maintenance of $1,480 allows her to clear the amount that she has outlined as monthly reasonable expenses in her domestic relations affidavit that we filed in this case. And it has also, and along with child support, and that will allow her to make sure that the child's needs are met in a manner similar to how the parties have provided for the child prior to the divorce being initiated and in the last couple of months. Ultimately, Your Honor, we also believe that in regards to the Capital One credit card, the monthly expenses contained therein as part of temporary orders, temporarily allocating that to the petitioner at this time will just ensure that the bills are paid. So, Your Honor, to recap, we are respectfully requesting that you adopt our proposed parenting plan based on the verified allegations that my client has made, based on the best interests of the child, under KSA 3203, her proposed parenting plan is most appropriate for the minor child because it allows both parents certainly reasonable parenting time, but allows the more involved parent to do the parenting. And finally, Your Honor, we are asking for $921 in child support pursuant to guidelines, as well as maintenance of $1,480. Thank you.
Mr. Andrews.
Thank you, Your Honor. Your Honor, first I would like to go through some of the allegations made in the verified motion, which we believe are inaccurate at best. The allegation contained in paragraph 5 that effectively puts the blame on my client for Ms. Bellar's medical state. We dispute. Just to give the court background, what happened is that morning, Ms. Bellar slipped in the shower and complained that she had hurt her knee. She did not indicate that it was anything, that she thought it was anything more serious than that, and that she was just going to relax and essentially take it easy so that she didn't make the injury worse. My client left the home to work, do some farm work. He came back about 4 hours later, and that was when he started to suspect that it may be something more serious because she was not very responsive to him. So he called the family doctor to find out what he should do. The doctor recommended that Ben take her to the local clinic. Ben called to make arrangements for somebody to watch the party's child so he could take her to the local clinic. But at that point, it was he had called the local clinic, and they had redirected him to go to the hospital in Andover. So Ben, Kristen, and Kristen's mother all went to Andover, and that's kind of an indicator on at least how Kristen viewed the seriousness of the situation at that moment. She insisted that they stop on their way to pick up the dry cleaning since it was on the way. Obviously, using 2020 hindsight, we know it was more serious than a slip in the shower and a bruised knee, but Ms. Bellar is attempting to recast what happened that day to paint Ben in a negative light, and we dispute that characterization. This was a situation that both of them were acting in what they thought was appropriate, and they were essentially in agreement on that at that moment in time. Paragraph 7 implies that Mr. Bellar is unwilling to.
You said paragraph 7. Hold on, let me see. You're on page 2, paragraph 7.
Yes, Your Honor, I apologize.
Okay.
Paragraph 7 implies that Ben is unwilling to or unable to assist Kristen with her day-to-day needs. He disputes that. He does work during the day. He is not in the home 24/7, and Kristen actually has her mother move in to help with that. So again, the parties had a structure in place that was intended to get Kristen the assistance she needed while allowing Ben to continue to work and earn money for the family. And now that's trying to be recast in a negative light to paint him in a negative way. Paragraph 10, my client does admit that when he was driving it was not a semi truck, it was a firefighting truck. Or a fire engine, I believe. He drove a fire engine to a school event, and he let the party's child ride in the fire engine with him. He did not have a actual child's car seat. in the moment, he did not think that it was something that they needed to worry about. But again, as we mentioned earlier, he is willing to comply with any legal requirements regarding car safety seats going forward. Paragraph 11 states that he was on his phone while driving with the child in the loaded semi-truck. He has a Bluetooth headset, so I'm not really sure what the relevance of that allegation is, other than trying to mischaracterize what actually happened in a way that makes it sound as though Ben was acting in a unsafe manner. Paragraph 12 talks about an incident where the child was left in the party side by side, and if they came to find out that the child knew how to turn on the side by side. That was the first time that it ever happened. So it wasn't something that he knew before that was something that she could do, or that it was an issue. She has not been left alone in the side by side since that date.
Okay, now when you say side by side, I want to be sure we're talking about, or I'm thinking about what you're telling me. What exactly is this side by side?
It's like a four-wheeler, I believe, but maybe a little bit more.
She listed as a Polaris Ranger, like a farm utility vehicle, 2 to 3 seats wide with a small utility bed behind it.
I don't know if you've heard it. It's kind of a small utility type vehicle. It's got 2 to 3 seats on the bench and then a flatbed behind it to haul property.
Okay.
It's not actually a Polaris, but I think that a Polaris is close to what it is, what it would be like. Paragraph 13. Again, he has not left. He has not left the child in the side-by-side unsupervised since the incident on September 16th. He did ride with her to into the field without a car seat, but that's not really a vehicle. I mean, again, it's a off-road, like a, I don't know, if it's what I'm thinking of, is like a souped-up golf cart, like a Razor or something like that, where it's not really something the parties have ever used a car seat before. Frankly, it's something that going forward, as I said, you know, we're more than happy to comply with any legal requirements for that. I don't know what those are with regard to car seats. So it's something that I would need to verify. But whatever the requirement is, my client's happy to do. Again, it's not something that the parties ever worried about driving around on the farm grounds before. Paragraph 14. Ben does take the child with him in the tractor. There's what's called the buddy seat in the tractor, which is something that's designed for children. He does not transport the child when the child is not in the buddy seat and properly wearing a seatbelt. But they did take he does admit that they did take the tractor. She was riding in the buddy seat. She was properly seatbelted in. But because of that, there wouldn't have been a car seat. And so then when they came back, he did transport her in a vehicle without a car seat. He admitted that he did do that. And that was not something that he intended to do again. That was not something that he regularly did either. Paragraph 15 implies that the tractor was in, or doesn't imply. Paragraph 15 claims that the tractor was in motion when the child was out of the buddy seat. That is not true. The tractor had been placed in, had been stopped. It was in park, and the parties were stretching their leg, or Ben and the child were stretching their legs. So she was let out of the car seat because the tractor was not in motion in order to stretch her legs. Paragraph 16, this is just not true. Ben was in a tractor that day, and the child was with his mother that day. So that allegation is just false. Again, paragraph 17, we acknowledge that with the side-by-side, it's not something that they've ever used a car seat before. But if that's what is legally required for that type of a vehicle, he will do that. Paragraph 18, he does not recall what he specifically stated to her in response to this. He does acknowledge, though, that he was probably uncooperative with the concerns because she had never had these concerns before when the parties were in a marital relationship. It was only after a divorce case had been filed and Kristen was seeking residency that she made these as an issue that was something to be concerned about. So again, my client, I think was probably more confused than anything in his response to that. We agree with paragraph 19 that the child should be in a legally required safety restraints. Paragraph 20, this implies that the child was exposed to harmful chemicals. That's not true. My client was working at that time with it wasn't insecticide or fungicide. It was herbicide. It was some herbicide, but they were never around the child. She was never exposed to them. This is again trying to mischaracterize the nature of his work to imply that there's a risk there that there is just frankly not. Paragraph 21, my client has never made any of these comments. These are completely false. Paragraph 22, subsection A. For the most part, these allegations are completely false. Kristen did typically schedule medical appointments. That was just kind of a division of responsibility between the parties. That's very common in any type of relationship where one party typically takes on more of a certain type of responsibility, another party takes on a different type of responsibility. Ben has, especially since the accident, been the one who's gotten the child ready for bed every single night and put her in bed. So it's just, one of those where each of the parties have kind of divided up those responsibilities, but it doesn't make him incapable of doing that. And now that the parties are going to be separated, obviously each of them will be more responsible during their own parenting time for stuff that the other party was maybe taking on a little bit more of when they were together. Subparagraph B, he denies that he stepped on her hand. If that happened at all, it would have been an accident, but he does not believe it happened. Subparagraph 22C, this mischaracterizes what happened. The child was being uncooperative while Chris was trying to brush her hair. She asked Ben to hold her hands, and so Ben did, so that she could brush her hair. This is common, that she would ask Ben to hold the child's hand so she could brush the child's hair because the child didn't like having her hair brushed. Again, this is a example of her now trying to cast something that had happened in a completely nefarious light to try to impugn my client's ability to parent the child. But there's no actual truth to that. He did place her in timeout for all of 30 seconds, which I think that, in my opinion, timeout is a good non-corporal way of trying to impose a consequence on the child who's misbehaving. Paragraph D, my client denies that he said this to the child. He does know that he looked at I think it was like a farm equipment or farm toy catalog with her to say, hey, these are some things that we're going to get for Christmas. But he did not tell her, look at all the Christmas toys you're not going to get. Again, that's being mischaracterized or just outright false. Subparagraph E, this is another example of when Kristen asked him to hold her hands while she was brushing her hair. He did it as she asked. It is inaccurate to imply that she was trying to get him to let go. That did not happen. Paragraph F, he most likely did pick up the fork that had fallen on the floor, but he did not step on it with his shoes. It was not uncommon because the child is of that age where she is throwing her fork and spoon on the floor fairly constantly for the parties to pick it up and put it back. This is yet another example of, now that the parties are going through a divorce, Kristen trying to use this as an example of poor parenting when nothing could be further from the truth. So with regard to the factual allegations, that would be our response. Regarding the request, we do agree that the temporary order is not viable. It did provide for orders based on the parties residing together without having any equal for when the parties separated. I did that because he didn't want to try to force out of the home before she was ready to find her own place to live. But now that we're at that point, we are asking for shared residency. We believe that both parents are capable of parenting the minor child and have parented the minor child capably during their entire relationship and the child's entire life. We dispute the characterization that Kristen was the only caretaker of the child, that her ability to stay home with the child. I think that while it's true that she could stay home with the child, I would note that there were a couple places in her motion where she indicated that she has trouble caring for herself. And she relies on her mother to provide care, which is understandable, and we don't see anything wrong with that. And she relies on her mother to help her parent the party's child when Ben is not around. Again, we understand that, don't have concerns about that. By the same token, Ben, to have the child with him during the vast majority of the time that he is at work. So he's not going to be required to find a daycare provider. He doesn't have a traditional job where he goes into an office and punches a clock. He works the farm ground that his parents own on the farm, and he lives on the farm grounds that his parents own, where he works. He does do some trucking from time to time to earn additional income. But that's not a daily occurrence. Also, his mother or his parents live on the land right next to his land. Well, it's not really his land. It's their land he lives on, but right next to his house is their house. It might be about a half mile down the road. And his mother has, even before the parties divorce, frequently watched and cared for the child while he was working in the farm because they have a good relationship. So we don't believe that the fact that he is employed and Kristen is employed means that this shared residency would not work. We believe that shared residency would work, that it is in the best interest of the child to have an equal amount of time with both parents in a situation where neither parent is unfit to parent that child. And there's no evidence that would suggest that Mr. Villar is unfit to have an equal amount of time with his child. So we're asking for a shared residency. We're requesting a week on, week off parenting plan with the exchanges on Sunday at 6:00 p.m. We are asking that child support be based on shared residency with a direct expense sharing plan. The proposed child support worksheet that I've prepared has Ben's income at $7,876 per month. Frankly, I just, in an effort to try to get to the number that we believed was accurate, I put that in as domestic gross income. I was somewhat trying to hurry to get a worksheet that actually had the number on file. So it doesn't have the gross business income minus the business expenses breakdown. But the gross income would be the same as that breakdown, or very close to it. I'm still receiving information and documentation from my client to support what his gross income and reasonable business expenses are. The amount that we put in the domestic relations affidavit was an estimate because we didn't have all of those documents in front of us at the time, which is why there wasn't a breakdown attached to it.
All right. I'm going to ask you, like I did, Ms. Hess, bottom line, what is it that your position or your client's position is on what should be paid on child support on a monthly basis?
Yes, Your Honor. We are asking for $480 per month child support with the parties to equally divide the direct expenses of the minor child, and then $1,000 per month in spousal support. With regard to Ms. Hess's arguments on business expenses, our position is that we agree that only expenses that are necessary to generate income are allowable business expenses. However, that can include depreciation. It can include all of the expenses that are listed in the 2024 income tax return. Ms. Hess asked the court to accept that the business expenses are only $7,920 per year, when what's listed on the tax return is $90,240 for 2024. Even removing the depreciation expense, that's still $60,000 in business expenses that she's asking the court to completely ignore. If the court wants to hear, is everybody else frozen?
I'm not.
Okay. Sorry, the screens were frozen, and I was worried that meant that I was disconnected and I was only talking to myself.
There'd be a little bit of a pause, but not what I would refer to as broke down. I think I got the gist of your argument.
Okay. So what I was saying here is that without depreciation, there was $60,000 in 2024 in business expenses, and Ms. Hess is asking the court to ignore essentially $52,000 of that business expense, arguing that because we haven't had a full evidentiary hearing to provide evidence to support that business expense, they should just be ignored. We don't agree with that conclusion. If the court wants to set the evidentiary hearing, we would be agreeable to that, but because of the complexities involved in this type of a business expense issue, I'm going to ask that we schedule at least half a day for that. And we're likely going to need to have an accountant or other expert come in to testify. Otherwise, I think the court can determine that most of these expenses, just looking at them for a long-haul trucking company, are going to be necessary for the generation of income. The income number that we are proposing, which is essentially a net income of 7,876 in-kind payments received from his parents for the grain sales for what he does during the year is an appropriate income number. We also believe that $1,000 a month is an appropriate amount for spousal support. Ms. Bellar, on her domestic relations affidavit, shows that she does not have a need spousal support above and beyond what would be paid through child support. We recognize that some of those expenses were based on estimates because the parties were not actually separated yet. We also recognize that Ms. Bellar's mother is going to be residing with her, continuing to reside with her, and assisting with that. So we believe that $1,000 a month is appropriate, and given my client's expenses that he's taken on, even without having to pay rent, he still has significant expenses that he's obligated to pay. That is what he can afford to pay, and that's an appropriate amount of spousal support that would be fair, just, and equitable under these circumstances. We are objecting to him paying the individual credit card in Kristen Bellar's name. One, because at the time, frankly, the card was at a zero balance, and so any expenses incurred are expenses that are going to be incurred.
Okay, now you
separation.
I wasn't able to hear
and she
you froze up.
Should be responsible for those expenses. I am so sorry, Your Honor. I don't know what's going on with our internet. It's not been right for the last month.
All right. In regards to the
credit card are going to be.
All right. In regards to the. All right. There's a delay to where you're talking at the same time I'm talking. And I know that's not generally how you operate. So I'm thinking that's a technical issue. In regards to the credit card, that's what the mother is using to take care of her day-to-day expenses as well as that of the child. Is that correct?
That is what Ms. Hess indicated, and our position is that she's already using those same. So by then requiring him the credit card payments, she's double dipping, if you will, and asking him not only to pay for her expenses, but then to pay spousal support that was ostensibly to cover those same expenses. We also object to the requested order that petitioner notifies or as being unduly vague and overly burdensome. I don't believe it's necessary to have an order that is so broad in a temporary order. Instead of Ms. Hess wants to ask what business expenses were or what business debt was in existence at specific dates, then those that information can be provided.
Okay.
And then the only other. Sorry, I apologize, Your Honor.
Go ahead.
The only other order that we're requesting is just simply that neither party incur any new debt on the joint Capital One credit card.
Is that being utilized for any of the businesses?
It is being utilized for the business, Your Honor. But frankly, we just don't want Ms. Bellar adding incurring expenses that my client's been paying for on the joint credit card. But I didn't know if the court would prefer it just to apply both ways. But I mean, really what we would be asking is that Ms. Bellar not incur any new expenses or expenditures on that joint credit card that Mr. Bellar is going to be paying on.
All right. I'm going to take about a 5-minute recess to review some numbers. And we'll be back in approximately that frame of time. Before we do that, Ms. Hess, was there any brief rebuttal that you had?
Judge, if I may briefly, Mr. Andrews' response to my client's verified sworn testimony is largely by proffer here. I want you to take that into consideration. Listening to what you
Your
have to
Honor,
say,
I'm going to object to that. The court asked if we wanted to present evidence beforehand, and to imply that my client's proffer should somehow be given less weight because we opted jointly to not present evidence, I believe is disingenuous.
Well,
Judge, if I may, he had sufficient time. This motion was filed on October 27th. He had sufficient time to file a response wherein his client could have rebutted this.
well,
That's frankly untrue.
Hold on. There's been a lot said that really I'm not going to get into the weeds on in regards to this for temporary orders. I think a lot of that needs to be dealt with in regards to the divorce case itself. In regards, I'm not asking you, Ms. Hess, to try to refute, A, B, and C, and and everything in that regard, but in the broad sense of like what your client is going to need, during the pendency of this case to be sure that she and the child are supported appropriately.
And frankly, Your Honor, when it comes down to that, if you take a look at what her DRA is, I'll direct you when you're taking a look at her numbers to KB12, which is the last page of her verified DRA. Her funds available to her on a monthly basis are $1,944 per month. She has a total need of $1,841 per month, which leaves her at a balance of $100 a month. This is before child support is calculated. If you are granting my Ms. Bellar primary custody, she's going to need some support to make sure that she's not operating at $100 a month basic margin every month temporarily. She's going to need some substantial assistance, and that would come in the form of child support. Your Honor, based on the numbers that have been provided today, we think that number is $921 a month, and we are asking for some reasonable spousal maintenance to continue to supplement that number. If you're granting us primary residency, we think the numbers are based out of the information that has been provided to us thus far, which is basically the tax return. We think that's equitable, fair, and would not be unduly burdensome on Mr. Bellar. So, Your Honor, when it comes to custody on this case, our position, she's been the primary parent, and that too, she's going to need some reasonable support, and our proposal outlines that. Thank you.
All right. I'm going to take a break to 3:30 to review some of these numbers and try to calculate, and we'll reconvene at that time. Thank you. We're in recess at this time. All right, we're back on the record. Be sure that the clerk is acknowledged that, and we're getting a recording.
Yes, Judge.
Thank you. This is for temporary custody. This is not designed to be an end all to these matters. I'm going to order that there be a joint custody with the child in regards to decisions being made and so forth. I'm going to, with a child being 2 years old, mother being disabled or her circumstance and the occupation of the father or occupations, there's a lot of times I don't think it would be appropriate for a 2-year-old to be in some of the workplaces that are necessitated when running a farming operation or trucking operation. So I'm going to place primary with mother with liberal time with father. Now, I've asked through council parties to come up with a workable plan that can be somewhat consistent in regards to schedules, how they permit. But I want it to be where I understand both homes is probably going to need assistance of other family members from time to time. With the mother in this case, because of her physical situation, and for the father due to the type of occupation that he does and supports himself as well as his family with. So I think it's important that a child have more, have adequate time with both. There's going to need to be some changes made than when the child was at home with one home. Clearly, if one party is always given the bath, that's not going to be available. But when you're doing the parenting, I want to focus on the actual parent doing the parenting and taking care rather than just farming the child out. And I'm not suggesting that's what's happening, but letting somebody else do that and take care of all of the needs of the child. The portions that have been agreed to will be adopted by the court. I'm going to ask the respondent to do the journal entry for this. In regards to the temporary payments on support, I'm going to set that right now at $800 a month child support. In regards to spousal maintenance, I'm setting that temporarily at $1,200 a month. Now, there very well may need to be adjustments in regards to that before, at the final orders. So I would caution the parties not to go too extreme in regards to debts and various things, because once final calculations are made, there may need to be some adjusting in regards to one party ordering the other or paying back the other. So in regards to, I'm not going to, the card, the capital one that's in respondent's name is her responsibility. The one that has both of the parties' name will be the responsibility of the father in this. Again, those are things that I'm not sure if all of those bills are going to need to be separate and distinct at some point in time. There's going to need to be probably, both names off of the various accounts. But the agreement in regards to who's paying what, the court is adopting those that have been admitted for the purposes of temporary orders. I'm going to order that the child support be paid through the pursuant to the guidelines through the state system. in regards if there is additional medical that for the child, that'll need, I'm going to order that 80% of that be paid by the father and 20% by the mother. Hopefully there won't be a circumstance that where this child has some additional issues. All right, now there was a lot of discussion in regards to safety of the child and these side-by-sides and so forth. And in the community I live in, there are a lot of those type of, I think somebody said glorified golf carts, but both parents are responsible for the safety of the child. And sometimes I see parents, and oftentimes both parents in a vehicle that I wouldn't think is appropriately safe for a child that for 2 years old. So make your plans around child seats and so forth. I think there's enough income where both families can have, or both parents will utilize or have their own car seats as need be. Operating of farm equipment, and I understand that farm equipment has been improved to a great extent for safety, but if the father's going to be taking a child on there, he needs to have his child secured correctly, and certainly not in a position where the child is able to disrupt the machinery, as apparently it happened once before. 2-year-olds can surprise us, the things that they can do, and that can happen just as easily. Certain things in the mother's home. This 2 years old, they're learning how to do things and experimenting with things, and toddlers need to be looked after, because everybody's home probably has lots of dangers if we're not careful. So our next hearing is going to be January 26th, as we agreed, at 2:00. We're slating an hour. That is a case management. Clearly, the more, and I would ask the parents to do their level best to work with each other in regards to what's in the best interest of their child. That's not easy at this time of going through a divorce. And there's going to be times where you're angry and so forth. Please don't talk about those things in front of your child. And I always encourage parents not to let other people talk about that in the child's presence. Even when it's an infant who can't understand, if one parent's being upset and you're holding the baby, I think babies understand that. So let's try to keep this to where both parents are looking out for the well-being of the child at all times and getting along as best as you can. You're not always going to agree. You both have very good attorneys, and there's a lot of work to be done yet. But I'm confident that both of these parents can keep this child safe in what they do. And but when they're in your care, that parent is the one responsible for being sure those the proper things are being done. And that may mean correcting a grandparent from time to time in regards to how something needs to happen. So, all right. Are there any other orders that I've overlooked that council need addressed? Ms. Hess, your motion. You're still muted.
Judge, pardon me if I'm missing this. We did request under section E of ordering joining parties from drawing against business accounts, except for the purposes of order of operating business in the usual and ordinary manner.
Okay, what's the number? You said subsection E.
I have it listed on, well, in my original motion.
I've
Your Honor,
been,
that was-
I've been working with
It may
you.
have reformatted itself for my hearing notes.
Okay,
Uh,
I'm working off of the motion to modify temporary orders that was submitted October 27th.
26G, Judge, I'm sorry.
Pardon?
That was one of the ones we did not object to.
Okay,
All right.
The
Perfect.
one we did object to was 26H.
26H. Now, other than, there's going to be necessity for discovery. I'm not going to, so there, at some point in time, there's going to need to be information concerning the business and income and various things. But I'm not going to make it an order that everything has to be reported, as every bill occurs. But obviously, there's going to need to be discovery at some point in time as well. So that may not make it any clearer. I'm sorry. Mr. Andrews, any other things that need to be addressed?
Only our request that respondent be enjoined from incurring any new charges on the joint credit card debt.
That's granted. Again, there probably needs to be a time where that's being separated out. But if one and the father is utilizing that, for personal matters and so forth, yes, it'll be almost certainly any debts that the respective parents and get themselves at this time they're going to be responsible for.
Well, he kind of met them in the middle. They were asking for $2,400. That's what Mom was asking for. And Dad was asking for it to be $1,480, I think was his, or 15. No, I don't know. I can't remember. It was $1,480 or $1,580 or $1,380. Anyway, somewhere around $1,400 to $1,500. And he gave Mom $2,000 total for both supports. And that seems fair, but he also cautioned, someone might have to pay someone back or pay extra to catch up. So, and, he did say that I want the parent to do the parenting, doing the care. I don't see how Mom can do that. I don't see how she can pick up forks that are thrown on the floor or catch the little one as they're climbing on a piece of furniture that's about to topple over. How can she do that? There's a lot of things. Bathing, She admitted that she can't even take care of herself sometimes. Well, if she can't take care of herself, then it doesn't sound like she can take care of her daughter either, in my opinion. And the attorney should have discussed that more, brought that out more, but maybe they were cautioned not to. Maybe that was part of the meeting in the back. I don't know, but I don't know. But I kind of got the impression that her chair might have been somewhat of a prop, like women that put low-cut tops on or have the little one in their arms. So I don't know. I just think sometimes they do that. I have no idea about this woman or her condition, so I really don't know. But they're going to have to come up with custody, care and custody arrangement. They're going to have to do it. He didn't give them a date, times and days and everything. They have to figure that out themselves, which is good. He should make them do it. He should make them figure it out. It should be them. So, anyway, thank you guys so much for watching, and I'll see you another time.